Two online and.
I will note that we have all but the treasurer here. He's excused. He should be joining us shortly. So I think you can proceed. And I think we were talking about maybe a couple of changes to the normal routine. So I'll leave that to you.
Thank you, Mr. Chairman. Yes, it's my understanding that the board would like to first convene today as the State Board of Land Commissioners to address those issues to help some folks out that may have some scheduling conflicts. So if that's still the board's pleasure, we can proceed in that direction.
Okay, without objection, can we open as the State Board of Land Commissioners? I don't hear an objective, so let's, an objection. I do hear an objective.
Thank you, Mr. Chairman. The first item on the agenda for the State Board of Land Commissioners, let me first start by saying this has been advertised as a regular public meeting for the State Board of Land Commissioners. The first item on the agenda is approval of the meeting minutes from the December 7th, 2023 State Board of Land Commissioners regular meeting.
Members, are there corrections, comments, additions to the minutes? If not, I'd entertain a motion to accept the minutes.
So moved, Mr. Chairman.
Thank you, Madam Auditor. Is there support for the auditor's motion? It's been seconded by the superintendent. All in favor signify by saying aye.
Aye.
That motion carries. Minutes are accepted.
Mr. Chairman, under item B, we have provided the board members with the usual reports. We don't have anything further to add to those reports at this time, but I believe we have staff to stand for questions.
Are there questions for the staff on the items under item B? Hearing none, we can move on.
Mr. Chairman, we've provided the board materials in advance to the board members and have briefed each board member individually prior to the meeting. At this time, I'm prepared to propose a consent list if the board would so desire.
I think that's a good idea.
Okay. The following items on the Board of Land Commissioners agenda for February 1st, 2024 appear to be amenable to treatment on a consent list. D1 through D4, and I note that D5 has been withdrawn. D6 through D9, E1 through E5, F1 through F7, G1 and G2, I1 and I2.
And for other board members, there are a few people with whom I'm familiar on some of the grazing leases. I have no business arrangements with them. If you'd like me to point some of them out, I'm happy to, but if not, I don't think there's any particular conflict that I can point to. Hearing none, if there is a consent list to be put forward on items D1 through D4, D6 through D9, E1 through E5, F1 through F7, G1 and G2, I1 through I2, I would entertain that motion now.
So moved, Mr. Chairman.
Second.
Been moved by the auditor, seconded by the superintendent. Is there any discussion? Hearing none. All in favor signify by saying aye.
Aye.
We have a consent list. I would, without objection, I would entertain a motion to approve the director's recommendations on the consent list. And again, for the record, D1 through D4, D6 through D9, E1 through E5, F1 through F7, G1 through G2, I1 and I2. I would entertain a motion.
So moved, Mr. Chairman.
Been moved by the auditor,
Second.
been seconded by the superintendent. Any discussion? Any discussion? Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Nays? That motion carries.
Mr. Chairman, the next item on the agenda is D10. I will turn this over to your conflict counsel, Chris Brown.
And Madam Director, I think to put that properly in front of us, we'll have to remove it from the table. Is that correct?
I'm sorry, Mr. Chairman, my mistake. Yes, Mr. Chairman, that matter was tabled at the December 2023 meeting. So in order for that to be on the table, the board will in fact have to remove that from the table and bring it before the board.
Mr. Chairman,
Yeah, Madam Auditor.
I would move that we remove item D10 from the table.
Second.
Been moved and seconded. Is there any discussion? Hearing none, all in favor signify by saying aye.
Aye.
We have a motion, we have a matter before us. Chris?
Mr. Chairman, good morning, members of the board. Chris Brown with the Attorney General's office here to talk about agenda item D10, which is to consider the Office of Administrative Hearings recommended findings of fact, conclusions of law and order on cross motions for summary judgment, an order vacating pre-hearing and hearing on October 20th, 2023 in the matter of conflicting lease application by Burnett Ranch Partnership for state lease number 1-7655. This matter is an appeal from the director's decision to conditionally award a grazing and agricultural lease to competing applicants, Jerry Loffelbein and Daniel Taylor, who I'll refer to as L&T, over current leaseholder, Burnett Ranch Partnership. Burnett Ranch held grazing and agricultural lease number 1-7655, which was set to expire on January 1st, 2023. On September 27th, 2022, L&T timely submitted a conflicting lease application offering to pay $1,580.64 annually. At that time, L&T also alleged that Burnett Ranch had been subleasing the lease without approval. On October 5th, 2022, the Office of State Lands and Investments contacted Steve Burnett, and he confirmed that Burnett Ranch had subleased the lease without approval. On October 7th, 2022, Burnett Ranch submitted a sublease application for a pasture agreement it had with Kennedy Ranch during the summer of 2022 and indicated that a total annual rental of $500 was paid by the subleasee under the agreement. On October 14th, 2022, OSLI sent Burnett Ranch notice of the L&T conflicting lease application and indicated that Burnett Ranch must submit a matching bid within 30 days of receipt of notice. On October 24th, Burnett Ranch submitted its renewal application, matching the $1,580.64 conflicting bid. At its meeting on December 1st, 2022, the board approved Burnett Ranch's sublease application regarding the previous summer's pasture agreement. On December 12th, 2022, the director conditionally awarded the lease to Burnett Ranch, concluding that Burnett Ranch was eligible to exercise the preferred right to renew the lease. L&T filed an appeal challenging the director's decision, alleging, among other things, that Burnett Ranch was in violation of the lease and was therefore ineligible for the preferred right to renew. During the time OSLI was assembling the record for the L&T appeal, OSLI discovered that it incorrectly determined that Burnett Ranch was eligible for the preferred right to renew the lease when it issued the December 12, 2022 director's decision. The initial director's decision incorrectly permitted Burnett Ranch to meet the highest bid offered by L&T. As a result, the director rescinded her initial decision and conditionally awarded the lease to L&T on May 1st, 2023. The director determined that Burnett Ranch's sublease application had not been approved by the board at the time Burnett Ranch sought to match the highest bid of the conflicting applicant. Therefore, Burnett Ranch was in violation of the terms of the lease and was not eligible for the preferred right to renew the lease under Wyoming Statute 36-5-105. Burnett Ranch timely appealed the director's decision, and the matter was referred to the Office of Administrative Hearings for a contested case. Both OSLI and Burnett Ranch filed motions for summary judgment. After considering those motions, the hearing examiner issued his recommended findings of fact, conclusions of law and order on cross motions for summary judgment and order vacating pre-hearing and hearing on October 20th, 2023. Generally, the hearing examiner recommended that the board grant OSLI's motion for summary judgment and deny Burnett Ranch's motion for summary judgment. Burnett Ranch timely filed the following two exceptions to the hearing officer or hearing examiner's recommended decision. Number one, the commissioner should reject the hearing examiner's recommendation to deny Burnett Ranch's partial motion for summary judgment because the hearing examiner ignored case law, which prevents the OSLI from rescinding a decision after an appeal period has run. And number two, the commissioner should reject the hearing examiner's recommendation to deny Burnett Ranch's partial motion for summary judgment because the hearing examiner unreasonably concluded that Burnett Ranch failed to timely cure the lease violation. In the recommended decision, the hearing examiner addressed both the arguments addressed in Burnett Ranch's exceptions. First, the hearing examiner considered and distinguished the case law relied on by Burnett Ranch and found that requiring the director to present and defend a decision to the board that is known to reflect an inaccurate application of the law is contrary to the inherent authority of administrative agencies to correct errors before they become final. Second, the hearing examiner found that whether Burnett Ranch's sublease violation is considered pursuant to Wyoming Statute 36-5-105 or OSLI's internal policy, Burnett Ranch was in violation of the lease provisions at the time it subleased without board approval and when it submitted its renewal application. In either case, Burnett Ranch could not exercise the preferred right to renew. Mr. Chairman, my recommendation is that the board accept the Office of Administrative Hearings recommended decision and issue a final order granting OSLI's motion for summary judgment, denying Burnett Ranch's motion for summary judgment, and upholding the director's May 1, 2023 decision to award the lease to Jerry Luffelbein and Daniel Taylor. And as I think the chair recognized at its meeting on December 7, 2023, the board considered this appeal and postponed reaching a final decision in this matter until this meeting today. The board also encouraged the parties to try and reach settlement of the matter, but it appears the parties have been unable to reach a settlement at this time. On January 26, 2024, Burnett Ranch filed a motion to stay the decision in this matter to await a district court decision in the Keim lease matter, which this board decided in August of 2023. This matter is similar to the Keim matter, but it's not identical, and the parties are different. On January 29, 2024, OSLI filed an opposition to Burnett Ranch's motion to stay. On January 31st, 2024, just yesterday, the hearing examiner found that OAH had no jurisdiction to decide the motion to stay because it had already returned the matter to the board for a final decision. And it denied Burnett Ranch's motion because it had been filed with OAH. The hearing examiner also noted that all further action in this matter is within the jurisdiction of the board. Because OAH lacked jurisdiction to consider the motion to stay, it would be appropriate for this board to consider that motion at this time. Also on January 26, 2024, Mr. Luffelbein requested the opportunity to present oral argument to the board. On January 29, 2024, OSLI filed a response to Mr. Luffelbein's request and asserted that oral argument will not significantly aid the board in resolving this matter and asserted that the request should be denied. Under the Wyoming Administrative Procedure Act, oral argument may be allowed in the discretion of the board. As noted by OSLI, if the board allows oral argument, arguments need to be limited to the evidence contained in the record developed in this contested case proceeding. As with the motion to stay, it would be appropriate for the board to consider the request for oral argument at this time. And Mr. Chair, I recommend you take up the motion to stay first.
Thank you, Chris. Board, you've heard the explanation, and I would entertain your motions.
Mr. Chairman,
Madam Auditor.
I would recommend that the board deny the motion to stay the matter at issue.
Thank you. The auditor has made a motion. Is there?
Second.
It's been seconded by the superintendent. We now have a motion before us. Is there discussion?
Mr. Chairman?
Mr. Treasurer.
Yeah, Mr. Chairman, I want to be clear, this motion to stay was only through, only through the time in which the district court made a decision on the Kine case. It wasn't through any subsequent appeals.
Thank you, Mr. Treasurer. Further comment, discussion? Hearing none. All in favor signifying by saying aye.
Aye.
Nays?
Nay.
Madam Director, Chris, I think for the record, that is going to be 4 ayes and 1 nay.
Thank you, Mr. Chairman. So, because the matter is not stayed, I think it's appropriate at this time to consider Mr. Lofelbein's request for the opportunity to present an oral argument. And as I mentioned, the Wyoming Administrative Procedure Act leaves that opportunity to the discretion of the board.
Thank you. Chris, before we go any further in this, can you just sort of outline, I think it's important that we know that these are more or less informal conversations, but there needs to be order and process to them. And I just wonder if you could kind of sort of set some ground rules and maybe some impression, for example, that the case can be added to at this point or not, and that sort of thing.
Absolutely, Mr. Chair, and I'll do my best. And I want to start with just the general principle. All this is it's a quasi-judicial proceeding, but as a general matter, it's informal. It needs to be orderly, but it need not follow legal technicalities as a typical court proceeding would. So I would just suggest to the board that we be informal with regard to it, but it needs to be orderly at the same time. With regard to the arguments, they're not evidence. They are simply meant to allow the parties an opportunity to argue about the facts that are developed in the record and present their position with regard to how the law applies to those facts to the board. It's not an opportunity to supply new evidence that isn't already contained in the record. The record was closed by the hearing examiner in this matter. And so, Mr. Chair, I would suggest that the board identify a length of time that the parties could each make an argument. As far as an order, I would suggest, because Mr. Lofelbein made the request, that he be given the opportunity to go first. And then because Burnett Ranch appealed the director's decision, I would suggest they go next. But they be offered an opportunity to reserve some time should they find the need to respond to the office's arguments. The office then would go next to make its arguments, and then if Burnett Ranch reserved any time, I would suggest they go last.
Thank you, and I think it's probably appropriate to ask if Mr. Lofelbein is here. He is, and is Burnett Ranch here? Okay, so I think all parties are here, and if that fits with the board, we'll proceed. And I think probably 10 to 15 minutes per individual. Does that sound about right?
I was thinking 10, 10, and 5, 5, 4 questions in response.
Okay. Mr. Treasurer, that sounds good. Mr. Lofelbein, please.
Mr. Chair, if I might, you might want to, I don't believe you took a vote on the motion.
Oh. All right, and we do have a motion on the, we don't, so should be a motion to proceed, I guess, is that correct?
A motion to approve the request for oral argument, I think, would be
Mr.
Chairman.
Request. Yeah. Mr. Secretary.
I move that we approve the request to proceed to, I move that we approve the request to have an oral argument.
Very good. It's been moved by the secretary, I believe seconded by the treasurer. Any discussion? Hearing none. All in favor signify by saying aye. Aye. Mr. Lifflebein, sorry about that. And as you're approaching, I know you attempted to get the letter to me because we have to be very careful about ex parte conversations. I wanted to let you know that was the reason that you were intercepted. I normally love to have people come to me, but I didn't want to in any way prejudice the proceedings of this panel today. Thank you for being here.
Go. Sir, thank you. Mr. Chairman, good morning and thank you for allowing us to speak before this Board of Land Commissioners today. And sir, I'm going to just read this whole thing. We just talked about that. I had something to present, but I won't, but I'm just going to keep on track with the letter that I had. Mr. Chairman, good morning and thank you for allowing us to speak before the Board of Land Commissioners today. With your approval, we have a small package of documents we'd like to present with some background data for reference. This information may be helpful in recognizing our awkward position outside of these official proceedings. It is intended to be complementary to the findings of fact already recorded and may help clarify non-actions as beneficiaries of this outcome rather than participating litigants. Until last week, we were not completely familiar with the rules of ex parte communication and restrictions at play to protect the sanctity of this process. Since our initial submission for application for grazing lease 1-7655 in Platte County, and as onlookers and independent citizens watching the case between OSLI and Burnett Ranch, we witnessed some things that appeared out of line and maybe contrary to proper use of state resources by way of actions of some involved. Frankly, we felt misrepresented and were confused as to why inclusion of relevant information would be obstructed unless an alternate agenda was afoot. As a result, we attempted to set a meeting with you, the governor, to discuss these facts. Feared time was short though. Therefore, we attempted to hand deliver a package in an attempt to afford you the opportunity to not be blindsided again publicly. This matter is dear to our heart and our neighborhood. The surprising outcome of the cautionary delay imposed on 7 December suggests the information may have been withheld during the executive session, and we feel that continuing without all the facts may place you in unfavorable light and possibly establish bad precedents. Furthermore, the pleading by Burnett Ranch Partnership for the motion to stay was a legal misuse, in our opinion, of the proceedings and a waste of everyone's time. The decision before the board regarding lease 7655 should stand on its own and not be delayed further by civil litigation that may linger for months or even years. This process has lingered for over a year, and we have tried other avenues to be heard within the confines of procedure outlined by OSLI, OAH, and the Attorney General's office. We've been patient and respectful in this process. We feel strongly that you, as the chairman, must hear the entire background in this case in order to accept any motion contrary to the recommendations of OSLI through OAH. If we do nothing else, it is our intent to aid the board in making an informed decision that benefits Wyoming resource development, animal husbandry, state monies, and our neighbors in this great state. We're here for the duration to answer any questions you might have pertaining to this or anything that is coming up. Thank you.
Thank you, Mr. Lifflebein. Are there any questions?
Yeah.
maybe straying outside the lines here, but I'd love to give a couple of opportunities, please.
Well, Mr. Chairman, I guess the attorney can intercept me here in a second, but I mean, first I want to say, like the governor, I've gotten a number of communications on this over the last 3 months, and if I didn't respond, it was because I was concerned about, jeopardizing the record. But I mean, your comments allude to some potential impropriety, and I'm wondering if you can delve more into that. That we don't. What part of the record would we not have currently that?
Sir, specifically the background. It appears in the conversations, I've watched these meetings over the year, and we are misrepresented as what I feel the bad guy. We're the outsider, we're not the cattle rancher, but we're the little guy. It appeared that we were going against the grain, because the particular grazing lease is geographically separated. There's 80 acres and a 640. I approached Mr. Burnett back when we did the application to see if we could divide that 80 and the 640. Well, we were told by OSLI that it had to be all or none. So we leaned forward with the all. And we went into the process with the application. And it was, it just appeared later on that members of the OSLI could have influenced what was going on, because we identified that there was no sublease on file, on record. That's already been discussed, and that's already in the case. Well, we approached Burnett for that, and he never got back with us. Well, then realizing that there was a subleaser, legal or otherwise, in the area, I reached out to Kelly Kennedy and Nick. I talked to Nick on the phone, and he said he talked to his dad about it. Well, as a subleaser, it really didn't matter, but it was our last gasp effort because it had been awarded to Burnett. And according to the rules per OSLI, once it was established and done, if we want it, then we could subdivide it later. If they want it, we could approach them and see if it could be subdivided. And we never got back. Well, fast forward to our appeal based on the fact that the sublease was not authorized or not legitimate, and therefore kind of destroyed any right they had to get preferential based on the previous ownership or previous holding. So we filed the appeal. And the director went through that with OAH and all of that over the time period and overturned it, pointed it to us. Shortly thereafter, Mr. Burnett approached and asked if we could come up with a settlement. And by that time, we decided collectively that we didn't like where it had come from and why it had happened, and that we weren't interested in going down that road. So that we thought was going to be a matter of record. Well, the hearing was set to discuss all of this in October, and then the calendar was vacated. So we were confused. We figured December would be when it was going to be discussed. It was shelved because, again, sir, it appeared that you didn't have all the information, or the board didn't have all the information. And out of the left came the motion to separate, which was confusing to us because if no information was allowed to the board from the outside, that was never discussed, and why would it be in the record? So how would anybody recognize that we had the intent or the desire any longer to subdivide that through OSLI? And we just leaned forward and said, no, we're gonna stay our ground and go for the whole thing, because we have come to decide that the words of subleasers or leasers, I'm not sure that I could trust it. So we felt that we would lean forward and try to do right by our neighbors who have been frustrated for years about the behaviors of ranchers on that particular lease with their livestock and everything else. Because we live, it butts up against a subdivision, if you will. Some folks have called it the lots. They're sub 40s, little ranchettes. But Burnett has in our grazing or in our covenants, the right to graze all of that that's not fenced. Well, most people have fenced, and Burnett hasn't had cattle in there for years. I've seen other cows in there. So we just decided we're gonna lean forward and try to do right by our neighbors and everything else. So
Thank you, sir. You've got 1 minute left.
time's up, I'm done.
I got another question.
Well, we'll store that for the time being, because I think we're within the rules here. We set out 10 minutes and then 10 minutes. And I'm not going to extend that. We can talk about what we do afterwards, if that's all right. Thank you. And Mike, Mr. Church.
And I just have this isn't a question, but it's, I guess it isn't a question, it's a clarification about how the subleasing or the request, I think, mostly for me, that you guys get together and you take your 80 and these guys get their 640, was that there was some testimony, I believe, from along about after that December issue, that was something that you had wanted to do, and I think that came from the Office of State Lands while they were testifying here. So it didn't come out of the blue.
And Mr. Treasurer, I'm going to lean to Chris a little bit.
So, Mr. Chairman, and I appreciate that, and just a suggestion, of course, as I suggested, we should be informal but orderly, right?
Yeah.
And I think probably the overriding principle is to make sure the parties have equal time. And I would also suggest that once the parties have an opportunity to present their argument, if during its deliberations, the board has questions that pop up with regard to the facts that required some clarity, the parties would be welcome to provide some clarity if the board would ask them, as long as everybody's given equal time. So perhaps some clarification questions, if necessary, as part of the issues that are actually in play, pop up, that could be appropriate.
All right. So I'll let you proceed. I'll obviously let the,
Try to make it short, and to the extent that you can just answer yes or no. It appears that once you got the high ground in the battle, you were, I guess, comfortable with staying there. Now, if the shoe were on the other foot, and at the end of the day, Burnett was in the same position that you are today, would you be more or less inclined, I guess, would you be, just say more or less, would you be more inclined to go back to the original position that you had to bifurcate these leases?
Sir, at this time, we collectively decided that no, we don't want to go back. That ship has sailed. We approached it in a neighborly behavior, and we were met with opposition, and have since decided to go for the whole thing because I think that's right by our neighborhood for certain.
okay, Mr. Secretary, have you follow it.
I guess, Mr. Chairman, I'd like to get your response to the board has been, I believe the precedent has been set that the board leans towards curing in a number of respects, but especially on these subleases. And there's a lot of different cases where we've allowed curing on these subleases. Now, Keim is a little bit distinct because the application period had passed, but I wasn't on the board at that time. I was going to go on a month later, but the sublease was approved on December 1st of 2022. And that to me is a very important point in this case. And it's the day before the application period had elapsed. And so I guess I'd ask you what your response is to that, because I believe that really the board for some time now has leaned on trying to be accommodative on the sublease matter, but also on renewals, and has been very accommodative to the existing leasee. So that's my question.
Well, that's interesting that you bring that up, only because the sublease has no date on it. It refers to the summer grazing period. which, since you guys have meetings every other month, between September and December is more than enough opportunity to have presented that to the board for approval. It appears that there was an en route and that sublease appeared later, because when I approached OSLI back when I spoke with Stephanie Coombs and her replacement Cody Booth, there was no subleases on record. So I, being new to all of this, laid heavily, depended on the professional opinions of OSLI. We literally followed their roadmap on how to do this, to the point where, again, in the beginning, we wanted to subdivide, but they said, you can't do that. That would have made the most sense. That was a long time ago. So the timing of all that in the end, that's legalese that I'm not really privy to. I just know what it appears to me. We leaned forward, filed the appeal. It has then been overturned, and I'm pretty sure the director of OSLI scrutinized that pretty thoroughly through OAH, and here we sit a year later.
Thank you. Superintendent or auditor, any questions? All right.
Thank you, members
Mr.
of the board.
Loffelman. Thank you. I have about 4 minutes of excess time, so that's fine. If the Burnetts would like to step forward, that would be great. Thank you. And again, apologies, it's a sort of a loose but relatively formal and orderly, I think your word, Chris, so thank you. Please identify yourself for the record.
Good morning. My name is Rachel Buzanowski. I am counsel for Burnett Ranch Partnership. First off, thank you all for hearing this matter this morning. We appreciate your guys' time and consideration. I would first like to start off by correcting a bit of what Mr. Loffelbean said. He made it sound as if the procedure in this matter has been, underhanded, or that we've been trying to hide the ball on something. And I'd like to set that record straight that that's absolutely not what has happened. Both us and counsel for the State Lands Office thought that this matter was basically a matter of legal issues and that there were no factual disputes. So both sides filed motions for summary judgment. And because of that, the OAH determined that this matter could be decided on summary judgment and that the hearing that was scheduled was no longer necessary. All of the briefs in this matter were served on Mr. Loffelbean and Mr. Taylor, and they had the opportunity to respond accordingly, but they chose not to participate and did not file any of their own briefs. So I just wanted to set the record straight that, things have been set forth and everyone has had an opportunity to participate. Moving on, I would like to discuss the cure aspect of this case and Burnett's compliance with its lease. The bottom line here is that the Office of State Lands and Investments and the director, their handling of this matter has not been in the best interest of the state trust land beneficiaries or the ranching industry, which is required by state law. Burnett Ranch has held this lease and has not had any issues with it for years until this matter. Upon learning of this issue with the sublease, Burnett Ranch attempted to correct any issues with it, and all issues were resolved before the lease renewal period expired. As has already been discussed, on October 7th of 2022, the sublease form was filed seeking approval of the sublease. On October 24th, the lease renewal application and the matching bid were filed. And then on December 1st, this board approved the sublease. Now, this is a lease that was set to expire on January 1st, 2023. So per the statute, the Burnett Ranch Partnership, as the existing lessee, had until December 2nd of 2022 to file its renewal application. And before that deadline, this board had already approved the sublease that had taken place on the lease. The director also has the authority to approve subleases on her own per the statute. She declined to do so, but regardless of that, as is already mentioned, this lease was approved before the renewal period had expired. The director argues that Burnett was not in compliance with the lease prior to submitting its renewal application. However, I think relying on that date as the deciding factor here is frankly a bit of an absurd reason. This board periodically grants subleases well after the fact, retroactively approving them. On today's agenda alone, out of the 20 some odd leases on there, nearly all of them were to be retroactively approved, including one lease that was seeking approval of subleases for the past 6 years. And this board never raises any issues with any of those things. The only reason it's a problem in this matter is because someone else submitted a conflicting bid. So it seems odd that we can approve subleases after the fact, but today it's a problem because of this, even though that sublease was approved prior to the renewal application period expiring. To quote a Supreme Court case in Wyoming here, Frolander v. Ilse, the Supreme Court decided that the right to preference is a very substantial right, and that the preference right of renewal should not be rejected on slight, trivial, or technical grounds, but only when this board finds on sound grounds that the greatest benefit to the state would not be subserved by granting it. Granting the preference right in this case, or rather acknowledging the preference right for Burnett, does not fail to subserve the greatest benefit to the state or the trust land beneficiaries. Burnett matched the bid that was offered by Mr. Lawfulbean and Mr. Taylor, so the state would be getting the same income off of this land as it would otherwise. And to further quote the Frolander case, this board should recognize the equities in those who have built up a ranching business in this state. In addition, it seems odd that an applicant would be permitted to trespass on a lease prior to having the lease in their name, and that wouldn't be an issue for granting them the lease, but yet a sublease that was approved before the renewal application period expired would hold an applicant back from exercising the preference right. Moving on to the original OSLI decision, as mentioned, was made in December of 2022 and actually granted this lease in favor of Burnett. However, in May of 2023, the director unilaterally rescinded and replaced her decision with a decision in favor of Mr. Lawfulbean and Mr. Taylor. It is unreasonable for the Office of State Lands to rescind a decision after the appeal period has already run and an appeal has been filed. As a result of that unlawful delay and a newly announced policy by the State Lands Office that when a lease is under appeal, that it must be left vacant, this lease did not have any livestock running on it this summer, which means it was not being leased by anyone. Now, how does that benefit our state trust land beneficiaries? Without anyone leasing the land, there's no income for the state. So again, I would like to highlight that the State Lands Office has not acted in the best interest of the state trust beneficiaries or the ranching industries in this state, both of which it is obligated under law to act in the best interest of. So unless there are any questions from you all, I would like to conclude by reminding you that Burnett did timely cure any issues with its lease, and I would respectfully ask this board to preserve Burnett's preferred right to renew and award it lease 1-7655.
Questions? Mr. Treasurer.
I just want to get a clear, I guess, understanding of what's on the ground. Is it 80 acres in a section of land owned by somebody other than Burnett?
I'm sorry, I guess
Well, there's, from what I understand, there's two parcels. One is 80 acres, and that's surrounded by a different landowner other than Burnett, and it's not fenced in.
Yes, sir. So between the two parcels, there is other land that is not owned by Burnett Ranch Partnership. There's also a BLM lease that is, or a couple BLM leases that are held by Burnett Ranch. Essentially, between that whole swath of land, much of it is relatively unfenced, and including the state section at issue here. The land that has been sold off in pieces, as was alluded to by Mr. Lawfulbean, it was subdivided off, and not all of them have been individually fenced. Through that subdivision process, Burnett reserved the grazing rights unless someone fenced him out. And so the entire swath of land from that 80 acres down through that section have basically been managed as one parcel, even though it's not all owned by Burnett. And as I said, it's relatively unfenced between it, including some of the state lands and Mr. Burnett's own private land.
So the land right around the 80 acres, that's all ranchettes, or is there another rancher that borders that 80 acres?
I believe the next actual ranch is to the north of that 80 acres. My understanding, and I would have to double check with my client, but my understanding is between that 80 acres and the section, it is ranchettes.
I'm trying to find out the reason why people are reticent about trying to split those into two different ones, but what you told me, that's all one separate management area right now, without any fences between anything.
I think there are some fences in there. So if you look at the front map, I guess, do you have the map in front of you by chance?
Yeah, I don't think it ended up in my book, but.
Okay.
Yeah.
So the section of state land off to the west side of that, there is a small piece of private land held by Burnett. And then off of the 80 acre section, there are two parcels held by Mr. Lawfulbean and Mr. Taylor. And other that within that block of land, it's my understanding that while there's some parcels that are fenced off with those ranchettes, but a lot of it is unfenced and is all managed as one unit.
Okay.
And Mr. Treasurer, I think we're approaching 10 minutes, so.
Mr. Chairman, I've got a question.
And I see the auditor has a question and the secretary.
Mr. Chairman, thank you. So, and I'm just making sure I'm going off of the record here. Is there a reason that the Burnetts did not file a sublease application until they, I mean, to put it very casually, were told on?
So previously, it had been Mr. Burnett Ranch Partnership's cattle running on this lease. And I believe that he had sold his land to the Kennedy family, or a portion of land to the Kennedy family previously, but he still owned the cows, and those cows continued to run on this lease until this very last year of this lease period, in which case he finally sold his cows out to the Kennedy Ranch. So it was the same cows running on it. Essentially, nothing had changed in their minds. It's been operated as it had been for years, but there was a change in ownership, and so it was just an oversight on behalf of Burnett.
Thanks. I want to make sure we preserve time, so.
Thank you,
please,
Mr. Chairman.
Mr. Secretary.
What are some of the implications for the board to move off this accommodative policy on subleases that you pointed out? And it's one of the things I think is very important in this case. So can you talk about what the implications are to the state from a policy and a legal perspective?
As far as, if I may clarify, as far as not retroactively approving them?
Yes.
Or so obviously, I think it would probably be preferred that the leases were approved ahead of time, but I think practically speaking, that can be very difficult. One, just looking at the ranching industry as a whole, especially if you're on a year-to-year lease on a sublease basis, it may not be until, right before grazing season when they figure out who is actually going to be putting cattle on the land. And so that can be difficult to balance with your guys' schedule of only meeting every other month. It can be very difficult to have a sublease actually approved ahead of time. But I think that in a lot of cases, it's, an oversight, as it was in this case, that, things are handled as they are through a ranch, and it's just a matter of doing business, and they forget that they often need someone else's approval to do so. But if you guys were to move off of that policy, I think it would be a great detriment to the ranching industry, as a lot of people would likely lose their leases, as has been at risk in both the Keim case and in this one.
Thank you, Mr. Secretary. I'll take the balance. Just a quick question. As a lessee or myself, and I think you said it's obviously better to have a pre-approved lease. But in this case, the lease expired a day after the sublease was renewed, correct? Or the renewal period
The
was.
renewal period, yes,
Right.
sir. The lease itself did not expire for
Right.
another month.
So would it be fair to extrapolate from the suggestion that you have that ranchers should just cure all their problems right at the last minute? Because these leases are usually for a long time. I do note that there are a couple that are a year old on the subleases that we're approving, but most of them are in the last quarter or the last half of the year. I think the oldest is September, other than the 2022 one. So I'm curious for advice, and I know you can't provide that to me, but I think the real precedent here that I worry about is if we routinely do this, which we do, but only in contested and only under circumstances where somebody's announced that, and I would say both to Burnett and Luffelbeim, these are tough issues. I've been through a few of these myself, and friends come to blows at times over these things. So this is a challenge, but I worry about the precedent of saying all we have to do is cure right at the very last moment.
Well, I definitely understand that concern. Frankly, I think that is a precedent that has already been set. I mean, like I mentioned today, there's a lease that has been subleased for the past 6 years that is on the, the director recommended approval of, and there's been multiple occasions where that's happened in the past. In this case, it was only for 1 year, the very last year in the lease. So obviously it's unfortunate that it played a role, or the facts went the way they did, but this was only for the very last year. At the conclusion of the lease, they did seek approval of it. So I think this potentially could be remedied in the future if the director were to approve leases, through the state lands office instead of waiting 2 months for all of these to come through the board. But I think there are some remedies that could be made in the future. Yes, sir.
Well, and I appreciate that, and I would also note, just for discussion, that there's been a certain amount of turmoil over the last little bit. The grazing sublease regulations have been at play in the legislature. There's a lot they can argue for being somewhat accommodative. But I just wanted to make the point that people should know what they're doing. They should respect the law, and they should work hard to make sure that they adhere to what the rules are.
Yes, sir.
Very good. Thanks. So Chris, I think our next is state lands.
Yes, sir.
Mr. Peters, thank you.
Mr. Chairman, members of the board, Jim Peters of the Wyoming Attorney General's Office, on behalf of the Office of State Lands and Investments today. The facts in this case, relatively straightforward. They've been outlined by your conflict counsel and also provided in the recommended decision from the Office of Administrative Hearings. So I don't want to belabor the particular facts, but I want to dive right into the legal questions that are here before the board today. And the first is whether the office correctly determined that Burnett Ranch was not qualified for the preferred right to renew granted by Wyoming Statute 36-5-105C. And the language of that statute is important, so I want to highlight a couple of key provisions. It provides that an applicant who's a holder of an expiring lease and has paid the rental when due and has not violated the provisions of the lease and is qualified under Wyoming Statute 36-5-101 shall have a preferred right to renew such lease by meeting the highest bid offered by another qualified applicant who has actual and necessary use for the land. And the statute continues to go on. But the question is, what is the preferred right to renew? The statutory rights granted to an existing lessee, that preferred right to renew is the right to match the highest bid submitted by another conflicting applicant. And counsel for Burnett just cited a Supreme Court case for Olander versus Isley. And that case does stand for the proposition that, that preferred right to renew is a very substantial right. But what's important is that the legislature has prescribed that that right is not absolute. there are certain qualifications to be eligible to exercise that preferred right. And that was a decision made by the legislature when enacting this statute. And those requirements are, 1, you have to be the holder of an expiring lease. 2, you have to have paid the rental when due. 3, and important to this case, has not violated the provisions of the lease. And 4, you have to be qualified to lease state lands. In addition to those requirements, we have to look at what the preferred right to renew does. It grants that lessee who meets all of those qualifications a right to match the high bid. So what OSLI and this board has approved most recently in the Kime matter is that we have to look to a specific point in time. And what is that point in time? That's when the existing lessee is seeking to exercise that right. So in this particular case, on October 24th, when Burnett Ranch submitted its renewal application and attempted to match the highest bid submitted by Mr. Lawfulbein and Mr. Taylor, that is that point in time that the office looked at in determining whether they were eligible for that statutory preferred right to renew. And at that time, though a sublease application had been submitted, there had been no sublease application that was approved. This is a very similar issue, as I mentioned, that this board considered and decided in the Kime matter just months ago. So on this particular issue, we would request that the board find that Burnett Ranch was not qualified for the preferred right to renew in Wyoming Statute 36-5-105C on October 24th. At that time, Burnett Ranch sought to exercise that right. There's been an argument by Burnett Ranch in this case that by simply submitting the application in advance, that they had done everything they needed to do in advance of trying to exercise that preferred right, and that the office's policy and the board's historical practice of having sublease applications come to the board for approval in the first instance retroactively provided that approval. The process is outlined in the record in this case, but just to reiterate this for the board, when an application for a sublease or a request for a sublease approval comes to the office will vet the application, make sure that it contains all the necessary requirements, including the lease area, the land to be leased, the amount of compensation, all of the information that's relevant. The office will look at it, and if it meets all the requirements, instead of the office or the director taking action on that sublease application, the practice is to provide that lease or to put it on the board's next regular meeting agenda for the board's consideration. Why is this a practice? This is a practice because the board, through statute, has the authority to override any decisions made by the director. We'd find ourselves in an awfully curious situation if the director approved a sublease and then the board later on denied that sublease scenario. Or alternatively, if the office rejected a sublease application and then the board approved it. This process that has been in place for some time assures that we have certainty with the process, and all applicants know once their application has been vetted, it will be presented to the board for consideration in the next case. And again, that's exactly what happened here. Though the application was submitted in advance of Burnett Ranch's renewal application, it was not considered by the board until its December 1st meeting, which happened long after Burnett Ranch sought to exercise that preferred right to renew. As a result, looking at the timelines and the statutory requirements for the preferred right to renew, the office correctly concluded that Burnett Ranch was not qualified for the preferred right to renew. And while there's no dispute about the policy reasons that the legislature has considered in creating a preferred right to renew and in sustaining grazing operations, again, those rights are not absolute. There are certain limitations on it. And the office, in executing the statutes, are bound by those statutory requirements. The second piece, and I want to slightly tangent, but again, being bound by those requirements, the other requirement is that the office does have a decision, or does have the obligation to issue a decision in a conflicting lease matter. Burnett Ranch has argued that the office's decision to rescind its first director's decision and reissue a decision was improper is simply not correct. Upon realizing the mistake that the office made, originally the office had issued the director's decision to conditionally award the lease to Burnett Ranch, concluding that it was eligible for the preferred right to renew. But upon gathering the documents to transmit this matter to the Office of Administrative Hearings for a contested case, discovered the error that it had made in looking at the timing of when the sublease application was approved and when Burnett Ranch sought to exercise that preferred right to renew. Administrative agencies have express and implied authority. The director has express authority to issue decisions on conflicting lease applications. And with that comes the implied authority that if there's a decision that's made that's incorrect or based on erroneous information, the director has the ability to correct that mistake. Otherwise, we would have a contested case before the board where the office, by rule, would be bound to defend its decision that it knows to be in error. And counsel for Burnett, in its briefing, cites a Supreme Court case that deals with a final decision by an agency that's subject to judicial review, and whether that agency, sitting as an adjudicative body, can rescind its decision. But that's not the case that we have here. What we have is the office simply issuing a recommended decision that ultimately goes to the board for final agency action. So it's fully outlined in our briefing on summary judgment, but I did want to bring up some of the differences in this scenario versus the case that was cited by Burnett Ranch. Mr. Chairman, members of the board, I'm happy to stand for any questions, but we believe that this matter is ripe for summary judgment, that there's not a factual dispute, and we'd request that this board affirm the Office of State Lands and Investments decision to conditionally award the lease to Mr. Lawfulbein and Mr. Taylor.
Thank you, Mr. Secretary. Mr. Secretary first, then you.
Well, thank you, Mr. Chairman. You know, as laid out earlier, all of the retroactive subleases just on the agenda today. So have they all waived the preferred right to renew because at some point in time they've been in violation of the lease?
Mr. Chairman, Mr. Secretary, that's a great question, and I'm happy you brought up that question. So the answer, it takes a little bit to walk through this, but the office's historical practices, if the statutory timeframes allow, and that would include also the renewal or the lease timeframes, then the office does have a practice of allowing its lessees to cure any issues, such as a sublease that didn't have approval. The office would allow that existing lessee to cure that approval. Again, the important caveat there is if statutory timeframes allow. So what we're looking at here, if there was no conflicting lease application, had this same scenario happened, then the office probably would have allowed them to cure that lease violation before renewing the lease. But what we have here is a conflicting lease scenario and that preferred right to renew timeline that's established in statute at the time that the existing lessee is looking to exercise that right. So had Burnett Ranch cured the sublease issue in advance of seeking to exercise that right, then there wouldn't have been an issue and the office would have determined that it would be eligible for that preferred right to renew. Directly to your question on retroactive approval, we still have to look at that specific statutory timeframe and when the lessee sought to exercise that renew. So it's the office's position that retroactive or subsequent approval of a sublease application does not retroactively make an existing lessee qualified for the preferred right to renew when they did not meet that at the required timeframe. There are other reasons for the board retroactively approving sublease applications. One that comes to mind is half of the excess rental that was part of the sublease arrangement is due to the board. The board needs to consider and determine what the half of that arrangement was, whether the lessee is a lessee into the future or not. There's certain obligations, financial obligations that are owed to the board. So that sublease approval is necessary sometimes after the fact, simply for determining what the amount owed to the board is.
You have a follow-up?
I do, yeah.
And then I'll go to the treasurer.
You know, Mr. Chairman, I guess, but your position is that the preferred right to renew, as you lay out, is contingent upon them following the lease, and that they're not following the lease when they don't approve a sublease ahead of time with the office. So wouldn't the office, under your position, be violating state statute? Because in the past, the lessee hadn't gotten a sublease approved?
Mr. Chairman, Mr. Secretary, the fact of having a sublease agreement in place without board approval is a violation of the lease. You're absolutely correct. The office and the board's, as I mentioned, historical policy has been to allow lessees to cure that, if they can do so within the statutory timeframes. As I mentioned, if Burnett Ranch had subleased in summer of '22 and in September or August realized that it had subleased without approval, submitted the application, it was timely considered by the board at its next regular meeting, which was in advance of the time that it sought to exercise the preferred right to renew, then the office would have likely issued a decision allowing or determining that Burnett Ranch was qualified for the preferred right to renew. When the office is making these considerations, it's strictly bound by the statutes in effect and the rules, and this is the office's implementation of those statutes and the rules by allowing that ability for an existing lessee through its leasehold relationship to cure the lease.
So, Mr. Treasurer.
You just said something that just kind of threw me a curveball there. I just want a quick answer on it. Does the approval by the director for a sublease, that has no ability to cure? It always has to be approval by the board?
Mr. Chairman, Mr. Treasurer, the director does not take action to approve or to reject
That's
a
not the
sublease.
question I asked. The question I asked is that whether both the board and the director have the authority to approve a sublease.
Mr. Chairman, Mr. Treasurer, yes, the statute
Okay.
says the director has the authority to approve subleases. The statute
Okay,
also.
that's fine. Now, does both the board and the director have the authority to rescind a conflicting case matter?
Mr. Chairman, Mr. Treasurer, if I understand your question correctly, it's after a decision has been made, so after the office issues a director's decision or after the board issues final agency action. The question is whether both equally have the ability to rescind the matter.
Yes.
Mr. Chairman, this gets into the case cited by Burnett Ranch in determining at whether there is final agency action or not. So the case that was cited by Burnett Ranch, in that situation, there was final agency action that was subject to judicial review, and the Supreme Court outlined certain considerations at when that decision to rescind happened. If it happened after the time for judicial review, then it might not be proper under that line of cases. But here, when the office issues a director's decision, that is not final agency action. That is just the first step to be able to present that recommendation to the board.
But the question I asked is whether or not the director has the option to either rescind or not rescind.
Mr. Chairman, Mr. Treasurer, it's our position that the director does have that implied authority, yes.
Has the authority but doesn't have the duty, or whether it's duty or not. They can or they can't, or they can let the board do it.
Mr. Chairman, Mr. Treasurer, I believe if the director knew the decision was an error, the director would have a duty to correct that decision.
Mr. Chairman.
Mr. Treasurer, I'm going to,
Mr. Chairman.
superintendent and auditor, and got about 3 minutes left.
Thank you, Mr. Chairman. So it's my understanding that when we talk about prior practice since early 2000s, that in the case of the timelines of the submissions, that the agency did follow prior practice. Is that correct?
Mr. Chairman, Madam Superintendent, that's correct.
Thank you.
Madam Auditor.
Mr. Chairman, we've the office has ultimately determined that that Burnett did not have the preferential right to renew. Should the land and I know nothing is clean, right? But in that situation, if we have a lessee that we've said, you do not get this right for whatever reason, would the typical process be to declare that land vacant?
Mr. Chairman, Madam Auditor, no. If the existing lessee, in a situation where there's not conflicting lease applications, and the existing lessee does, for whatever reason, is not eligible for the preferred right to renew, the office's historical position is that the existing lessee can still seek to renew that lease. If there is a conflicting lease application and the existing lessee is not qualified for the preferred right to renew, they can still seek to renew that lease application. However, by not being qualified for the preferred right to renew, what they lose is the ability to match the high bid submitted by another applicant. So if a conflicting applicant submits a bid that's higher than the minimum, the existing lessee would be unable to match that high bid. As you recall, in the Farner lease matter that was considered by the board last year, we had a conflicting lease scenario, but the conflicting applicant sought to renew at the minimum, and the existing lessee, who the office determined to be ineligible or not qualified for the preferred right to renew, also sought to renew at the minimum. So the matter was decided on, I believe it was Wyoming Statute 36-5-107, on which, when there are equal rental offers, that the lease be awarded to the entity holding lands closest to the lease lands applied for. I hope that answers your question, Madam Auditor.
And thank you, Mr. Peters. I'll note for the record it's about a minute over, so appreciate, but there was some back and forth. I think we're fairly informal, but I want to make sure. Specifically, Burnett's did not reserve time, but I'm going to offer them time. I'm kind of flying blind here, so if the Burnett's would like to.
Thank you, Mr. Chairman. Just a couple brief points for you all. So first off, I would like to point out that the sublease in this matter, there was no payment due to the state in it. There was no payment above that of the state lease. So there was nothing to be paid back to the state. So there wasn't any issues there. I would also like to point out that while the sublease was not approved until after the fact, this was not a fraudulent thing. It was a simple, oversight on behalf of the lessee. And the loss of the preferential treatment in this matter does seem to be in contrast to the law set in the Frolander case. It is a, trivial thing here, a technical matter, but the preference right is supposed to be a very substantial right. And the issue that happened here, especially since it was cured and there were no additional funds owed to the state, to take away that preference would be a slight or trivial matter as quoted in the Frolander case. Additionally, I would like to state back on the cure issue. The preference right at play here seems, it hasn't been, all these subleases don't seem to be handled evenly. They're only at issue when the cure is only at issue when someone places a conflicting bid. And so in the subleases that you all approved today, well, I'm pretty sure, judging by the request for approval of 6 years of subleases, I'm guessing their lease is up for renewal. Here, it's a 3-something lease, so it's, probably up the 1st of March. Apparently there must be no conflicting lease, or they're going to try and have it approved before their renewal application period expires. But it would be unfair to approve subleases and allow folks to, receive that retroactive approval and continue to keep their lease in matters such as that, but then to treat it completely different and, throw away a preference right on something that you all have not treated as being a substantial thing with the other subleases. So I would, again, just request that you all allow Burnett to exercise their preferred right to renew and overturn the director's decision and award this lease to Burnett.
Thank you.
Thank you.
Chris, I'm trying to make sure we have fair time for all parties. So,
Governor, I think you've done an excellent job.
okay, so, and I, here's the thing. And I'm thinking back to probably 1989, 1990, somewhere in there, when we had to move our cows. We moved them down to Warren Riff, a great man, loved him to death. He was a wonderful guy. I have no idea. We were in a drought. We had no grass. We had to move all of our yearlings down there. Warren provided pasture. It was a great deal. We were in a rush, and we were trying to figure things out about how to keep cows. And so I understand that there's stuff that happens that makes it, in the heat of the moment, difficult to understand all of the regulations. I would say that in my experience over several years, that the board has tried to be accommodative as much as possible. I would also point out that the Office of State Lands and Investments doesn't have a big staff, and I don't think any rancher would want to have people coming and checking their books every day. And so, we're in a challenging set of circumstances. We rely, much as we do with oil and gas leasing, on our lessees to make sure that rules are being followed, and occasionally those things turn into contentious cases. I've seen several of those contentious cases where neighbors have lost friendships, lost grazing rights, lost leases, lost their ranch. And so these are not insignificant matters. And I don't think they hinge on rigid application of the rules, because that's the issue we've been trying to resolve for the last few years. So I think this is a difficult case, and I respect both parties' positions tremendously. And I look forward to the discussion this board has. But I think trying to prosecute the staff of the Office of State Lands is misguided. I want to be clear about that. I think people try to do their best, and occasionally presented with facts, and they try to make the decisions they do, and sometimes those are incorrect decisions. And that's, I think, why the purview of those decisions comes before us to ratify or not ratify. So just wanted to state that. Thanks. Chris, what would you suggest the next?
So, Governor, I believe it would be appropriate at this time for the board to consider the recommended findings of fact and conclusions of law of the Office of Administrative Hearings. Again, my recommendation is that you accept those recommended findings of fact and conclusions of law, but of course, it's only a recommendation. It's up to the board to make a final decision in this matter.
All right, members of the board, what is your suggested course here?
Mr. Chair.
Mr. Secretary.
Well, I think we have two possible courses, and I have a motion that made it the last one. The last one, I was gonna make it again. I'll make it at this time. I move to accept the hearing examiner's recommended decision, accept the portion of his recommended decision concluding that Burnett Ranch failed to cure any lease violations before the director issued the December 12th, 2022 decision, and was therefore ineligible to exercise the preferred right to renew by matching the highest conflicting bid. Osley should have provided Burnett Ranch with a full renewal period to cure its past lease violation or until December 2nd, 2022. Because the board approved Burnett Ranch's sublease application on December 1st, 2022, it successfully cured its lease violation prior to the end of the full renewal period. As such, I also move that the board override the director's May 1st, 2023 decision and grant summary judgment to Burnett Ranch on that issue, that Burnett Ranch is eligible to exercise the preferred right to renew the lease by matching the highest conflicting bid, and that the hearing examiner's recommended findings of fact, conclusions of law, and order be modified accordingly.
Thank you, Mr. Secretary. Is there support for the Secretary's motion?
Second.
It's been seconded by Treasurer. Is there any discussion?
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Chairman. While I certainly have sympathy for all parties in this case, I think this is a very difficult decision that we work through. And of course, there can always be better communication. I think there should have been better communication. Rescission of decisions creates uncertainty for everyone, and I have sympathy for those producers in that case. I've said in the last several instances on this one that I don't in fact think that the statute is ambiguous enough to interpret that we can cure, and would like to see that fleshed out, and if there's a need to change that. And so I do believe that at the end of the day, if they had violated the lease, particularly in this case of a conflicting bid, I'm just a strong believer in that there should be fair competition for our state leases. And in the spirit of free competition, the opportunity for someone to bid. And so I just strongly believe in that for our state leases. And so, I fear that by not accepting the hearing officer's recommendation, we set a precedent, not only, I think, in violation of the statute, but also in violation of past practices. Timelines do matter in this case, and that's where I think that there's differing, as we've heard, opinions of earlier matters on the agenda. But I do think those timelines matter. I think that I don't believe this is in this case, but I think this sort of practice incentivizes violations, and in subleasing where it could benefit the producer rather than the state is very serious to me, and that impacts our beneficiaries, and that's not the precedent that I think that we should be setting. And so that's where I'll come down today. Thank you.
Thank you, Madam Superintendent. Further discussion?
Mr. Chairman.
Mr. Secretary.
Well, thank you, Mr. Chairman. And I think this case is very difficult, as you said, have respect for all the parties. And certainly the board is really, per the treasurer's recommendation, tried to provide some time here for a settlement where it wouldn't be all or nothing, but that did not happen. So we're in an all or nothing situation, and that always makes things difficult because there is going to be a clear winner and a clear loser today. But I just come back to the fact, and I think this is why it's distinct from Keim, that the sublease was granted the day before the lease renewal expired. And if you go against that, I think the implications to the state, to ranchers, to be able to conduct their business practices is very real. And I don't think you can do it in a way, per our line of questioning of Mr. Peters, I don't think you can do it in a way that makes any sense. We granted all these subleases today. How many of those are in violation of their leases and in this very similar time period as Burnett Ranch in this case? And so I'd pose to the superintendent, I think she's got to study all those cases, and in terms of her, if she's going to be consistent, then align her votes accordingly on their subsequent renewals. And I just think it's very difficult to be consistent if you're not going to allow the cure up to the moment of the lease renewal expiring, or the application renewal period expiring. So the timing worked out in this case. It won't always. I think in Keim it came too late, and therefore my vote was to not do the preferred right to renew in that case. But on this one, it was the day before, and that's where I come down. And then you also untangle all the reversals and things. It's just, I just don't think it works in terms of having our ranching communities able to align with the statute and be able to conduct their businesses with this precedent, if Burnett is not allowed to practice their preferred right to renew. So this motion to me is about consistency, allowing small businesses to be able to operate in a very complex environment and with seasonal considerations, as you lay out, Mr. Governor. And so I think we got to be consistent. So thank you.
Thanks, Mr. Secretary. Further discussion?
Mr. Chairman.
Madam Superintendent.
Thank you, Mr. Sharman. Well, I appreciate the secretary's calling out of me this time in this meeting on the board. I have a question for the Office of State Lands, if I may, on those that were approved earlier today. I believe that number one, those have no conflicting applications and that they have not reached their renewal period. Is that correct? Or the lease hasn't been expired?
And Chris, I'm going to ask.
You know, I think it might be appropriate to ask the parties if they have an objection, but I think it's an appropriate question considering it was brought up by Burnett
All right.
Ranch.
Are there objections from either party? Okay. Cody, thanks. You thought you were going to get out of this, huh?
Mr. Chairman, Madam Superintendent, I believe that to be correct. There are no leases renewing that are conflicted that fall into this scenario on the subleasing board matter.
Thank you, Mr. Chairman.
Thanks, Madam Superintendent. Mr. Treasurer.
A couple of things. A follow-up on that. There's no conflicting leases as of yet, but are there any of those leases that are more than 30 days out?
Mr. Chairman, I don't think I understood your question, Mr.
Well,
Treasurer.
the question is that we cured them today, but are any of those leases that aren't going to be subject to the actual renewal date isn't until 31 days out? So somebody could walk into the office today and present a conflicted lease.
Mr. Chairman, Mr. Treasurer, we have passed the deadline to conflict leases, and none of these 1- leases before you today have been conflicted.
Okay, Mr. Chairman, but I think that potential does exist, that somebody could come in and ask for a cure, but it would be in a situation where they'd be 31 days out, and just like that, somebody could go in and find ourselves in the same position that we are today. So that's the precedent that I think that the Secretary was contemplating. And so although it doesn't exist in this subset, I think that in the future, because it happened once, or actually maybe even twice in the Keim case, for whatever reason, it could happen again. Now, I have a cure for that, but it's not necessarily relative to the situation in front of us, and it's not a problem that I consider that's a problem of OSLI. I think it's a problem of board matter that we have to address. But I guess, Mr. Chairman, to follow up, I just look at this situation and I feel that the board matter that we had when we cured that lease, that was the final say. That was a board's decision. And at that point in time, then people should have the right to rely on the board's decision. And one of the things that it does when you cure a sublease, the thought is, I think, in everybody's mind, the reason you cure the sublease is to make sure that you actually preserve that preferential right. And so that's what we do when we cure that sublease. We're not doing it just as a matter of just basically putting a postage stamp on a letter and sending it out there. We're actually doing something that has more than just the act of putting the stamp on it. We're actually getting the mail delivered, and that mail can, basically includes, what the crux of it is, that there's a preferential right that is preserved. And so I see that as a final board action that we did at that time in December 1st. And that's how I look at this particular situation. And that's why I seconded it, and that's why I think it's important. And though I know we've had time and time again, is that the reason for the preferential right is actually to try to preserve, you know, the cattlemen in the state, because when you start with not having some kind of continuity between the ability to ranch, then you start losing the ability of having a industry that Main Street can rely on, that everybody that in the community can rely on. And so those are the reasons why you have a preferential right. And from my perspective, that was a formal action, you know, to basically preserve the preferential right by approving the sublease.
Thank you, Mr. Treasurer. Madam Auditor.
Mr. Chairman, and I think the treasurer makes many good points. I would maybe add on to one thing. I don't believe that filing, I don't think ranchers file subleases just to prefer the preferential right. You know, and this may sound too sunshiny, but I think they do it to comply with the law, and it's the right thing to do. And Burnett admittedly made a mistake, got called out on it. I think if they were retiring and didn't give a darn where this lease went, I think they would have filed their application and made sure they didn't owe any money, so the state didn't come out with them. So I don't know that I would connect the two in that same way. I think most of these people either got, you know, told on, or have realized that they've been, you know, have violated the law and are trying to correct the issue, hopefully just at the last minute.
Thank you, Madam Auditor, and I would simply say I agree. When I do that, I do it because I want to comply with the law. And I think most ranchers do. I will also say that there's been, it's a confusing set of circumstances. And so it's understandable why people could make a mistake. But in this case, it appears to me that Mr. Leffelbein also runs cattle as well, and Mr. Taylor does. And, you know, a lot of times, Mr. Treasurer, it's not just the big nasty guy that's trying to cut down somebody next to them. It's actually two ranchers and maybe it's one that's trying to expand their operation or not. In our case, Warren Buffett was our neighbor, and we took a shot when they didn't adhere to the law, because Warren Buffett, he was allowing some people to run cows there, but we wanted it to be able to expand our operation. So I think there's a lot of motivations to that, and I think a lot of times there are two sides to every story, and this is true here. So I'll say, are there any more?
Mr. Chairman?
Yes, Madam Superintendent.
Sorry, just one other quick thing, and I appreciate all the comments that have been said and by the treasurer. I think where this also becomes really complicated is the timeline, and different dates matter, and how people are viewing those. And so to me, there's no hypocrisy or non-consistency of votes, because with the application filing time and their renewal application versus when the board approved that sublessee. And so it's, you know, folks' different interpretations of the timeline, but I stay true to that. Thank you.
Thank you. If there is no further discussion, I will call for a vote on the motion. And so we know what we're voting for. Mr. Secretary, would you restate it?
I move to accept the hearing examiner's recommended decision, accept that portion of his recommended decision concluding that Burnett Ranch failed to cure any lease violations before the director issued the December 12, 2022 decision, and was therefore ineligible to exercise the preferred right to renew by matching the highest conflicting bid. Osley should have provided Burnett Ranch with the full renewal period to cure its past lease violation, or until December 2nd, 2022. Because the board approved Burnett Ranch's sublease application on December 1st, 2022, it successfully cured its lease violation prior to the end of the full renewal period. As such, I also move that the board override the director's May 1st, 2023 decision and grant summary judgment to Burnett Ranch on that issue. That Burnett Ranch is eligible to exercise the preferred right to renew the lease by matching the highest conflicting bid, and that the hearing examiner's recommended findings of fact, conclusions of law, and order be modified accordingly.
All right, you've heard the motion. All in favor signify by saying aye.
Aye.
Nays?
No.
I hear that as 2 ayes and 2 noes. I love this kind of predicament. I really do. No, I don't. I feel for all the parties here, and I think wonderful arguments have been made on both sides. I am going to vote on the no on this. And so that's my decision.
Mr. Chairman,
Madam Auditor,
may I make another motion?
please.
Mr. Chairman, I move that the board accept the Office of Administrative's hearings recommended decision and issue a final order granting OSLI's motion for summary judgment, denying Burnett Ranch's motion for summary judgment, and upholding the director's May 1, 2023 decision to award the lease to Jerry Lawful Bean, and I apologize, I know I'm pronouncing that wrong, and Daniel Taylor.
Second.
It's been moved and seconded. Is there discussion? Mr. Secretary.
Well, thank you, Mr. Chairman, and certainly echo a lot of your comments that I think there's been a lot of great arguments and have a lot of compassion for both sides on this. This is an all or nothing deal. And so I guess I just want to reiterate that I think the implications here, granted, some of the legislative changes may mitigate some of that in the future. And I think in that way, this could be very distinct, maybe. But I think the idea that folks that are curing are not able to exercise their preferred right to renew, I think there's major implications for this on small businesses across our state, and I'm concerned. So I think it's going to be interesting to see the way it plays out, and you know, in terms of consistency, which I have concerns about, and some of the different things that may have already happened that may be inconsistent with this. But I just wanted to make that noted for the record. Thank you.
Thank you, Mr. Secretary.
Mr. Chairman,
Mr. Treasurer.
I just let you know why I'm voting against this is because I believe that essentially, more likely than not, both these parties broke statutes that would necessarily not allow either one of them to lease this land. In this particular motion, I believe the parties were accused or allegedly had trespassed and broken the laws of the state. And I know there's an interpretation in which it is out there as far as what it takes to be able to be qualified to lease land. And I think because a trespass was on state lands, I think it rose to the occasion that it should have been if it would have trespassed on anything else but state lands, it probably wouldn't rise to the occasion, but because it was on state lands, I think it rises to the occasion that disqualified this particular person who wanted to lease state lands. And so that's why I'm voting against this.
Thank you, Mr. Treasurer. Madam Auditor.
Mr. Chairman, just real quickly, I echo everybody's comments. This is a really tough issue, and I feel like there's been a lot of these over the past 5 years where the decisions are shaky. You know, we are not making necessarily, there's not a good choice, there's a less bad choice or a slightly better choice, and this is reason 586 for me why we really need more flexibility in the statutes and we really need more discretion, and the legislature has given us none. And each year they pass more bills that give us less as opposed to opening it up a little bit more. So I appreciate you know, that the board has done things in a lot of different ways over the years, but this section of law keeps getting opened up and more detail every year. And so these just keep getting harder, not easier. Thank you.
Thanks. Further discussion? Mr. Treasurer, just, I want to say I kind of agree with your sense of the circumstance here. If there is no further discussion, all in favor signify by saying aye.
Aye.
Nays? No. I'm going to vote in the aye. Mr. Treasurer.
Briefly, while it's fresh on my mind, the fix that we could have with this is that we would have the director approve all subleases with the exception of those that are within 29 days of the last date or the date in which the lease has to be, I guess, applied for. And that way, Mr. Chairman, we get out of this catch-22, and we don't have to have that in front of us. And if it's a situation that we have to approve them, you know, it'll be after that catch-22 period.
Yeah.
Yeah, so I think that's something that, as a policy, we would direct the director to do.
Yeah, Mr. Treasurer, I think there may be an opportunity here to kind of look at a way to maybe in rule or something, try to figure out how to obviate against these.
Yeah.
Inadvertently, people do make mistakes.
This has burned a lot of time. Had we had something like that, it just would have been taken care of.
Yeah. So with apologies to all parties concerned, this is not an easy matter. So, all right. Further comment on this? If not, thank you, Brown. Madam Director.
Mr. Chairman, I believe the next item on the agenda is the Forestry and Fire Report from State Forester Kelly Norris.
Thank you, Forrester. I loved the picture you sent me of the prescribed burn. Oh, it's in Buffalo's watershed.
Good morning. Yes, I figured you might have been getting calls, so I sent a photo from my mother's house. Yesterday, the Bighorn National Forest created a prescribed burn in the Buffalo municipal watershed, and it went off very well, from what we can tell. And so I think they're watching it the next couple of days. I know snow's a-coming, but it was perfect conditions, and I'll send you all the pictures. It looked really great, so hopefully it went off very well. Burned in the roadless area, right above Bull Creek State lands, actually.
Oh,
So,
really?
Yeah,
Oh, good.
yeah, so
Did we know about it?
we did.
What are you up to now, daughter?
I know, right? All right, well, thank you, Chairman and members of the committee. I'm going to begin my report with a fire update. Our final numbers for the 2023 fire season are in, and Wyoming had 515 fires on a total of 10,789 acres. This was obviously well below average for fire season. Our 3 EFSA fires from last season have accrued a total cost of approximately $2 million. State Forestry has been processing up the last of the 2023 fire bills, with 675 bills already paid and another 18 left to go. We were just recently reimbursed by the U.S. Forest Service for a large amount of bills we sent in December and expect another large payment to arrive in the next few weeks. Snowpack is about 85% in the southwest and even lower at 70% in the northeast portion of the state. Normal fire potential is predicted for Wyoming through April. We have had 3 fires already in 2024, adding up to 0.3 acres. One was on state trust lands in the Black Hills, and state forestry did respond. It is annual operating plan meeting season, and state forestry has organized these pre-season fire meetings with federal, state, and county entities within all 5 districts throughout February and March. We also scheduled a pre-season fire coordination meeting with Camp Guernsey and Platte County at the end of this month. Camp Guernsey is planning a fire training exercise this spring on their property out there, and State Forestry and Platte County plan to participate in that training as well in preparation for this coming fire season. Moving on for a quick staff update. We had almost all of our vacancies filled until mid-January when we had our District 4 District Forester leave us for the U.S. Forest Service. We will be conducting interviews for this position next week and hope to have that replacement soon. Transitioning to the Good Neighbor Authority, an update. State Forestry has been in early discussions with the Mule Deer Foundation and the National Forest Foundation, who both hold keystone agreements with the U.S. Forest Service in regards to implementing project work within Wyoming's only designated at-risk fire shed, which is located near Du Bois within the Shoshone National Forest. We are being asked for assistance to provide our expertise to develop and implement project work on federal lands with the funding through both of these NGOs. Another new development in our G&A program is our plans to contract out specialist surveys for the Black Hills and Medicine Bow Route National Forest to help with the NEPA planning efficiencies. In particular, we will be contracting out northern long-eared bat surveys in the Black Hills to help with the required Fish and Wildlife Service consultations. We believe that through G&A and completing these surveys, it'll help with the project decisions needed to be made to increase that pace and scale of work within the Bear Lodge District. State Forestry was able to complete 118 LiDAR plots for the Black Hills LiDAR project. The U.S. Forest Service is currently working on analyzing the data collected to better fit the LiDAR modeling. We are expecting to have a completed LiDAR data across the entire Black Hills available for review this spring. Lastly, I want to update the board on some regional and national forest policy issues. State Forestry has been very busy this last month developing comments for federal land management proposals. We did make comments to the Rock Springs RMP proposal, specifically addressing concerns with wildland fire management, forested lands, invasive species, and ACECs. On December 20th, 2023, the Department of Agriculture announced the notice of intent to prepare an environmental impact statement to amend all 128 land management plans within the National Forest Service system, including to be consistent direction to conserve, maintain, and recruit old-growth forest conditions. The NOI has an extremely quick timeline for completion, with a final environmental impact statement to be done by January 2025, less than a year away. This proposal is deeply concerning because it undermines agreed-upon guidance within our current forest plans and our ability to engage in this amendment process. In our comments, we have asked the Department of Agriculture to reconsider this proposal and rather to focus their limited resources and efforts in reducing the impacts from the leading cause to old-growth loss, which is wildfire. We do not want this new initiative to slow down any active management or hinder our forest plan amendments that are already started within Wyoming. So I plan to keep the board updated as this new initiative progresses throughout this year. And with that, I will end my presentation here and stand for any questions the board may have.
Thank you, Kelly. Questions? Mr. Treasurer.
Just, one thing, we're always too busy here as a board, but hopefully at some point in time, we'll have some time to actually think about improving what we get off of state lands, and whether it's grazing or whether it's forest lands. I mean, kind of put that on the back of your head, if there's anything that, something that the Office of State Lands or this board could do to actually improve the return back to the beneficiaries on forest lands.
Mr. Chairman, Mr. Treasurer, thank you for that. We'll take that into consideration. We are developing a new program that we will probably be bringing forward in the near future with our inmate program, where we are collecting native Wyoming seed off of state trust lands. And we believe as we have this product and continue and have enough of it for ourselves to look at replanting in burn areas, we're also looking, it's very well desired in the seed area because people do not have Wyoming native seed. And so we believe we have another commercial product that we will have becoming available and another resource off of our forested lands.
The other thing, Mr. Chairman, is follow-up is that I've been doing a little bit of work with Nyman's a bit. I know you guys did a lot with the Oregon lumber and stuff, and we found a port in Oregon that's actually thinking about shipping coal, and they have a wood pulp plant where they get wood pulp chips in right across the river. So I want to probably get some time with you in the next week or two to actually talk about some possible things that we can do there.
Mr. Chairman, Mr. Treasurer, that'd be great. Thank you.
Thanks. Auditor, Superintendent, I'm talking about.
Well, I want to thank you on the comments on the old growth forest. Very comprehensive. I hope they land with a thud and make a difference, because that clearly, and I actually wanted to ask you a little bit about that. You said something, we have an at-risk forest above Du Bois. Is that old LP and US plywood land, and is the forest decadent? And
Mr. Chairman, yes. So the designated at-risk fire shed is the result of the wildfire crisis strategy. And so what happened is, interesting enough, Wyoming, on the first initiative of the wildfire crisis, did not receive a single priority fire shed. There was a pretty unhappy delegation we had and raised concerns and asked the Forest Service to re-look at this. When the second round of priority fire sheds were selected, we happened to have one land above Du Bois on the map. It did not receive technically funding, but what we have found is the Keystone agreements through these NGOs were told that they had to set aside a certain amount of money to do work in this specific fire shed. Yes, this fire shed is full of dead, old, decadent trees. Wyoming, we ran the numbers. There's 9.2 million acres of National Forest Service lands in Wyoming between Region 2 and Region 4. 3 million of that is in wilderness. Another 3.2 is in roadless. The majority of all those lands are sitting in a predicament to burn in the near future. And so we, again, are really pushing our federal partners to continue to manage their lands so that we can continue to handle and hopefully reduce the negative impacts of the wildland fire issue that is going on in Wyoming.
Well, thank you. And we just lost our Region 2 forester, who is a huge friend to Wyoming.
Yes, I did not include that into my update, but that is correct, Chairman. Jackie Buchanan, our Deputy Regional Forester at a Region 2, was promoted as the Regional Forester at a Region 6. So we will not be seeing Jackie here anymore in Wyoming, which is sad to say, but we will be waiting patiently. They have quite a few holes in Region 2 now. And so more than likely, moving forward, it'll be Frank Bim, the regional forester himself.
Very good. So we have reason to have hope that we have a consistency of management there.
Great question. We are working on that.
Okay.
And one of the things we are working on at State Forestry is shared stewardship. And what we've been working with an executive committee with Region 2 and Region 4. Again, shared stewardship is looking at our lands and having our federal partners understand Wyoming's priorities and working together and what that should look like and cross boundaries and the impacts that decisions that are getting made on those lands and what they mean to state and private lands. And so we're working together through a process to hopefully come together with both regions and say, hey, this is where Wyoming wants our priorities to be. Let's work together and make this happen. And part of that is also just getting Region 2 and Region 4 to talk to each other as well, and having some consistency because we are only Idaho and Wyoming have to share a region with the Forest Service. All of the other states have only one region to have to manage with and deal with. And so when we have inconsistencies, whether it's requirements and agreements or with fire management, how they interpret between two different regional foresters, all of this is part of where we're trying to go with shared stewardship, is we come to agreement and say, this is where we're going to go together.
Thank you.
Yeah.
Further questions? Any? Excellent job.
Great. Well,
Thanks.
thank you.
Madam Director.
Mr. Chairman, that concludes the agenda for the State Board of Land Commissioners today. I don't know if it would be a good time for just a short break here.
I think that's appropriate.
And Mr. Chairman, before we depart, I just wanted to mention we have some Merry Mountain cookies here in the back to celebrate Amanda Sewell. It's her last board meeting. She will be retiring after 30 years of work for the state of Wyoming. So, and we are having a celebration for her tomorrow afternoon that you all should have received invitations to. So with that, enjoy the cookies.
Well, thank you. We get to see Amanda up here in a moment, right? Okay. 15 after? Does that work? Okay. 2 minutes now behind 10:15, so I will reconvene us. The treasurer is in the room, so we have a full quorum.
Thank you, Mr. Chairman. We are now to the State Loan and Investment Board meeting. The first item on the agenda is approval of the meeting minutes. We have two sets of meeting minutes, the December 7th, 2023 State Loan and Investment Board regular meeting minutes and the January 8th, 2024 State Loan and Investment Board special meeting minutes. I will leave it to you to decide if you would like to take them one at a time or together.
Oh, let me ask if there are any corrections on either or any comments on either set of minutes first. If there are none, I would entertain a motion to accept both the December 7th and the January 8th special meeting.
So moved, Mr. Chairman.
That's been moved. Is there a second? Is there a second?
Oh, second.
Thank you, Mr. Secretary.
Yeah.
Is there any discussion? Hearing none. All in favor signify by saying aye.
Aye.
That motion carries. I will note for the record that both the superintendent and the treasurer stepped away briefly. So,
All right, Mr. Chairman, we have a number of reports that we have provided to the board behind tab B. We do not have anything further at this time to add to the reports, but we have staff here to answer any questions, should the board have any.
are there any questions? Are there any questions? Are there any questions? Boy, it's Amanda's last one. We've got to have some question for Amanda. Well, I'm sure we will. So, thanks. Please proceed.
Thank you, Mr. Chairman. We've provided the board materials to the board members in advance of this meeting, and we've briefed each board member individually. At this time, I'm prepared to propose a consent list if the board would like.
With no objection, I would entertain a proposed consent list.
Mr. Chairman, the following items listed on the State Loan and Investment Board agenda for February 1st, 2024 appear amenable to treatment on a consent list. F1 and F2, G1 and G2, and J1.
So F1 and 2, G1 and 2, and J1.
Correct.
If anyone would like to make that motion for the consent list, that would be very much in order.
So moved, Mr. Chairman.
Second?
It's been moved and seconded. All in favor of the consent list as described? F1 and 2, G1 and 2, and J1, please signify by saying aye.
Aye.
Are there nays? There are none. We now have a consent list. And I would entertain a motion to adopt the director's recommendations on the items on the consent list, F1, 2, G1, 2, and J1.
So moved, Mr. Chairman.
That's been
Second.
moved. It's been seconded. Moved by the auditor, seconded by the superintendent. All in favor? Is there any discussion? Let me ask that. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Nays? That motion carries.
Mr. Chairman,
Madam Auditor.
I would just hope that anybody that came for any of those issues have lovely trips home and drive safely.
And I hope they enjoyed their, watching us work our magic. Thank you very much for coming. Yeah, please. Mr. Mayor, come on up. I don't know. When I'm in your town, Monty, sometimes you take a liberty with me. I might just do that with you.
See, I gotta have help too. So I just want to tell you that we come down and met with council and governor, that I really appreciate how we were treated and how you guys come across as to us and listen to our concerns and the problems we're having. So I just want to thank you guys all very much for everything you do for the state of Wyoming. I was listening earlier, and I've been in those situations where you guys put us there to 2-2 or a 3-3, and you got to make that decision. So it's tough. So like I said, I do want to thank you guys very much. I think you got a great staff right here. Beth, we can't thank you enough for you and your staff helping us out, and we're looking forward to working with you guys in the next few years. So we have lots more projects to do. We do appreciate it. Thank you very much.
Thanks.
Can I
Thanks,
shake your
Marty.
hands?
Yeah.
What do you say?
All right. Thanks, Mayor. I'll see you soon. Yep.
I thought he was gonna do one of those. Thanks. Thanks very much.
Mr. Chairman, the next items on the agenda are with the Treasurer's Office. We have the D matters and the K matters. I know that we have some, or potentially have an executive session on one of those, so I would suggest maybe we do D1 and then the K matters and then come back to D2, but that's up to the treasurer.
Perfect, Mr. Chairman.
Thank you, Mr. Treasurer.
Mr. Chairman, our first one up here is the consultant report. We've got Josh Keevan on there. This is a review of investment performance. It's informational only. And I see Josh and I see Patrick. Patrick, you want to introduce Josh, make any comments that you feel pertinent, and then Josh, you can take it away.
Thank you, Mr. Chairman, Mr. Treasurer. Patrick Fleming, CIO for the Treasurer's Office. This is a very light meeting, no managers today, so I'll just pass it to Josh to give you the overview from our performance. Thank you.
And before you begin, I just want to congratulate you on what sounds like a great promotion, so.
Thank you, Chairman. Much appreciated and looking forward to it. So I will, Josh Keevan, Senior Consultant and now CEO-elect of RBK. I will start on page 3. And just a quick note here, this is preliminary. This is December 31st values, but we don't yet have quite a bit of the private market valuations in particular. So these numbers will continue to change a little bit as we get those private values in. But for at least the public markets part of your portfolio, this does represent the results of the first half of this current fiscal year. And just a quick note here, we do show you a total fund market value, including all of the funds listed that you see here, just over 28 billion. And I think that's the first time I've seen that total number above 28 billion. So I haven't confirmed this with deep research, but quite possibly a high water mark. I'll turn you to page 4 and talk about performance at the total fund level here. And you can see some pretty good numbers. You see the month to date, that's the month of December, 2.5%. Quarter to date, that's the 3 months ended 12/31, right at about 5%. And after a negative first quarter to a slightly negative first quarter of your current fiscal year, that brings you solidly into positive territory for the first half of this fiscal year. November and December in particularly were good months for markets as we started to see some of the inflation data cooling a bit. And the December Fed meeting, they struck a much more dovish tone than we've seen in some time. And markets started to price in expectations for the Fed policy to ease substantially in the next year. I will note that in January, and especially with the Fed meeting this week and some of their comments, that enthusiasm for that has waned a bit. But overall, markets are still pricing in some easing of policy this year. I would also note that on the numbers here, we posted this report before we had all of the real estate, core real estate fund values. And we know that's been the weakest section of the market. You can see the index was down 7% for the 2 quarters ended 12/31. We have since gotten the your results from your core real estate managers, and your core real estate portfolio. It shows up here as minus 1.59%. With the updated marks from the rest of your managers, it's actually minus 4.7. So you are outperforming the index in this period by a pretty good margin. But these numbers will be a little bit lower as we update those private real estate marks. That brings the total fund down about 20 basis points. So all of those total fund numbers you see at the top, you can adjust down about 20 basis points to reflect that reality that we now know about for the declines in the real estate portfolio. For the full calendar year to date last year, we show you 9.9% at the top there. That's net of fees. And that is, again, a roll-up of all of the underlying funds, which, as you know, include a wide range of risk profiles. But the total fund index, the comparison against that, this is the difference between those two is notably quite positive. We show you 1.4% here. It's with those real estate values, it's about 120 basis points or 1.2%. That's a very healthy degree of outperformance over the calendar year of 2023. And then in the graphic in the bottom half of this table, just showing you kind of for the first half of this fiscal year where the performance is coming from across all of the different asset classes. Generally, it's been a good market. You can see equities all largely up anywhere from 6.5% to 8%. One of the better performers in your portfolio have been MLPs. So those midstream energy assets continue to be a very strong contributor to performance. And that's actually continued to outpace other asset classes in January. The S&P, for example, in January is up about 1.5%. The MLP index is up about 4%. Real estate, as I mentioned, sort of the one weak spot, and a lot of that coming from the weakness that you would expect to be seeing in commercial office in particular. You've also had a nice write-up on one of your infrastructure investments. So you can see your infrastructure portfolio, also a very healthy 11.2%. For the rest of the asset categories, core bonds are up 3.5%. Most of your diversifiers around that, sort of your other hybrid fixed income categories like private credit, bank loans, EMD, you are seeing a little bit of outperformance above core bond markets so far this year. On page 6, we'll summarize some of the performance for the individual funds. For the permanent funds, both permanent mineral and common school, those results are kind of right in that 5 to 5.5% range for the first half of the year. For permanent mineral, your longer term oriented funds that have a more mature allocation to private equity in particular, those returns were a little bit better than what have historically been the income focused funds. 12% last year for PMTF and about 10% for common schools. And just focusing on PMTF, the last 3 years really kind of stand out because it's been a period of time where you've had, 2 of those years were generally very good years for risk assets, but one of them was very challenging. And over that period of time, that a sort of simple public markets benchmark that's used as a reference in investment policy and a statute, that 70% equities, 30% bonds, over that 3-year period where we've been, as I mentioned, kind of a mini market cycle recovery last year. 70-30 gave you about 3%. Your portfolio was about double that at 6% on the PMTF. And it's really a credit to the asset allocation decisions that you as a board made going back a couple of years where you really started to shift the portfolio more towards cash flowing, income oriented assets, where there was a higher predictability of what those returns were going to be based on the nature of the cash flows, you know, things like MLPs that have high cash flows, things like infrastructure that have durable contracted cash flows, as well as your build out of things like private credit, and really kind of moving out of the way of interest rate risk at the right time. You know, just really nice to see how that's played out for you there. Workers' compensation, the yellow rows there, fiscal year to date up about 4.2%. But last year in your investment policy work, one of the changes that you made to the policy for workers' comp was to really bifurcate that into two distinct portfolios, and you see that reflected directly below that. So there's now a portion that is the excess asset long-term reserve, which is comprised of assets above the estimated liabilities of the system, and the liability hedging assets, which are really just designed to match the duration, interest rate risk, et cetera, of the liabilities, projected future cash flows or obligations of the workers' compensation system. And so as we go forward, you'll see we'll continue to report on that, but you can see the estimated liability index was up about 3.3%, tracking pretty close with that, just a little bit under it at 3.1, with some nice outperformance coming from the longer term reserve assets up about 5.3%. As you move to the next page, LISRA, and total LISRA has grown to about 1.8 billion. It is somewhat evenly divided amongst these three underlying categories, although the largest allocation is in that short-term reserve, based on, I believe, some expectations for distributions or potential distributions. But very, very strong returns on LISRA, 10% in total or 9.6% net last year, with the biggest contribution coming from that long-term bucket, with a 19% return. That's actually, of all of the different pools, that was the highest returning pool for 2023. And then below that, you can see a similar total fund return for Pool A, 9.6% net, and 4.6% for the state agency pool. You know, last thing I'll point out is page 10. What this chart shows you is, you know, one of your primary objectives is to maximize the risk-adjusted returns of the assets. And what we're showing you here is the reference, the rolling 3-year Sharpe ratios, which is basically a return per unit of risk measure. It's on the top half of the ratio, you've got returns above cash, and on the bottom half you've got the volatility of those returns. So it's a measure of how much return did you get for each degree of risk that you took, and we're showing you this over lots of different 3-year periods. The sort of start on the left hand side, that's the 3 years ended January of 2009, all the way to the right, which is the 3 years that just ended 12 of 23. And the dark purple line, that's that 70-30 sort of simple reference portfolio benchmark. And the green line is the Permanent Mineral Trust Fund. The blue line is the Common Schools Permanent Land Fund. And just noting here that generally you've got a very good history over lots of different time periods of strong risk-adjusted performance. But it's really sort of been remarkable over recent periods on the far right. Especially as risk-adjusted returns for that simple stock and bond mix have come down. Now, you can't spend Sharpe ratios. You can't distribute Sharpe ratios to the beneficiaries of these funds. So it's still important that the returns, the total returns, are high enough to meet the long-term objectives of these funds. But this is a good testament to the fact that that's being done with good efficiency of risk, how risk is utilized in these portfolios. And we will be, just sort of a forward-looking comment, we will be meeting with the IFC in Cheyenne in March for our annual update on the strategic asset allocation. So looking forward very much to that discussion. It's always a very robust discussion with your investment funds committee, and then reporting back and working with this board on what comes out of that discussion with the IFC in the April timeframe. So, Mr. Chairman, I'll stop there. Happy to answer any questions that the board has.
Great, thank you, Josh. Are there questions? I had two questions, Josh. One was you mentioned about the private equity, and that's always wonderful, but it's always sort of imputed what the returns are. And I guess the question I have is, do we have a notion of how much leverage is being employed?
Yeah, Mr. Chairman, that's a good question as it relates to private equity and leverage. Oftentimes, especially in the buyout space, leverage is part of the toolkit that these managers are using to enhance returns. Patrick, I see you popped up there. Do you have any specific metrics on the degree of leverage in the private equity portfolio?
Yeah, yes, thank you, Mr. Chairman. Josh. Mr. Chairman, it really spreads across each one of the funds. We have not computed yet the leverage across all of them on a weighted average basis. But the one thing that we have been focusing on is, just because the valuations we feel are still stretched on a multiple basis, that the funds that we have been giving our money to have been on the lower end of the leverage side. So we're definitely lower than the market average, but I do not have that figure, but I can get it for you.
Okay, no worries, thank you. And then the other question I had, and on the real estate portfolio, it seems to me we still have legacy UBS. Is that still true? And what do we do about, is that somewhat challenging? Because that's a very old investment, and I don't know if
Yeah, Mr. Chairman, you're correct. You are, as I understand it, still in the redemption queue for UBS, as are many other investors. You and many other investors have been for some time. UBS, all of real estate is challenged now, and almost every fund in the open-end core equity index has a redemption queue. UBS unfortunately went into this period of difficulty with a fairly large redemption queue, and the current environment has sort of made that challenge more difficult. Other than taking a pretty significant haircut on the secondary market, there's not much that can be done about that, and other than to continue to monitor the situation. And Patrick, I don't know if you have any other comments, either from the real estate group that you work with, or from your team's perspective.
Yes, Mr. Chairman. Yes, you're spot on that. And it's been years that we've been trying to get the money back, but the queue is quite large and the distributions are small. I had a conversation last week, in fact, with the head of the UBS's group, Joe Hazelby, and they are looking at alternative ways. Before, they were just trying to grow their way out and do some other things, but now they're looking at all options of trying to remedy the queue, and potentially, whether it's through a merger, selling assets, or doing some other things, that they feel that it's a different stage and they want to remedy that in a shorter order. So hopefully over the next year, we could potentially see some movement there. But as Josh alluded to, the issue that we're having, especially in the office space, you saw the news yesterday, that is just a really dire situation, and valuations are anywhere from 25 to 70 cents on the dollar in some of these Class B and C properties, which is problematic across the board.
Yeah, well, and I'll note that investment precedes both me and the treasurer, so it's a challenge, and you as well. Probably you, Josh. I mean, it was probably before you were born. So anyway, thank you. Any further questions? Mr. Treasurer, any color?
Just, I'm glad to see it's finally over 28 billion, you know. No, I think that the crew's still doing well. That it's problematic, I think, on some of the things that we are looking at, that the LNG permit freeze came about, because I think that's gonna hurt both our LNG price on the state level and some of the opportunities that we were I guess, doing some research on in the Gulf Coast. So we'll see, you know, I guess we're gonna check out those permits there and find out what if any permits are needed in the properties that we're looking at, because that might help. But yeah, it's in this thing where Biden wakes up one day and makes up his mind to do something. There's more volatility with him than there ever was with the previous you know, president, as far as our natural resource industries and our lack of opportunities sometimes. So
absolutely
challenging.
Very good. All right. Well, thank you. Anything
Thank you,
more?
Mr. Chairman.
If there's nothing more, then I think, as per your suggestion, Madam Director, we would move on to the K matters. Is that correct?
Correct, Mr. Chairman. Board of Deposits.
The first one is, I think everybody's seen this every quarter. So it's the quarterly TDO8 rate establishment. And the table is on the second page there, and the rate on a 90-day T-bill is on average 5.45. So, Mr. Chairman, that's the rate that the banks would be charged for their deposits. And so the motion, Mr. Chairman, is that the State Treasurer requests that the board accepts the recommendation of the TDOA rate to be established using the one-year Treasury bill average for the full calendar quarter preceding this meeting, October 1st, 2023 through December 31st, 2023. The rate of 5.45% will be the fourth quarter of the TDOA contract year 2023 to be effective April 1st, 2024 through June 30th, 2024.
Second.
Been moved by the treasurer, seconded by the auditor. Is there any discussion? Hearing none, all in favor signify by saying aye.
Aye.
That motion carries.
Mr. Chairman, the collateral report, that's a quarterly report on the institutions who avail themselves of the TDOA program, and their collateral position is on the K3 matter. It's informational only, and the overall is that there's a collateral of 498 million and a account balance on deposits of 322 million. And so all banks are on the right side of that ledger. And so there's a few banks that don't avail themselves of the loans. But a lot of these are that don't are some of the larger banks and some of the more national banks. But most of our community banks, that's one of the programs that's been effective in allowing them to have capital available.
Very good, thank you. Yeah. Mr. Treasurer, and that mountain of, forgive the pun, mountain of paperwork K2 is still there.
K2, is K2 still there? Yeah. Okay. I did, and right over, huh? Okay, okay. Oh, yes, Mr. Chairman, this is to accept the eligible list of depositories to receive public funds. And there's an additional location, the First Northern Bank has been added at the location in Douglas, so apologize for having fat thumbs on that one, Mr. Chairman. But the motion would be that the state treasurer recommends that the board accept the state treasurer's recommendations of the list of eligible depositories to receive public funds on deposit.
Second.
It's been moved by the treasurer, seconded by the auditor. All in favor signify by saying aye.
Aye.
Nays? That motion carries. Madam Director, I think that leaves us one more matter. Is that
Correct, Mr. Chairman. D2.
So, members of the board, it has come to my attention that it might be advisable to hold a brief executive session on this to take legal advice. And so we move this matter to the end, and I would entertain a motion.
Mr. Chairman, I would move that we enter into executive session for the allowed purpose of receiving legal advice.
Second.
It's been moved and seconded. Is there, I guess I'll say, all in favor signify by saying aye.
Aye.
And nays? We are going to go into executive session. Madam Director, are we going to stay in this room or?
Mr. Chairman, it's my understanding we're going to stay here, but we're going to make sure we clear the room.
Okay, and then Mr. Bump, Director, is that correct?
Mr. Chairman, that's correct. That's the last remaining matter for the board's consideration today is D2.
Okay, and this is regarding large project loan program recipient, Atlas Carbon LLC. I believe we have folks here possibly from Atlas Carbon and possibly from Wood. I want to make sure we offer an opportunity for them to approach if they are so inclined.
Mr. Chairman, good to see you again.
Good to see you.
It's been 2 years. I am positive you have been relaxed because I have not been before you. Mr. Treasurer.
And you need to identify yourself.
Yes, indeed. I am Reza Hashimpour. I'm the chairman and CEO of Polaris Asset Corporation. And I stand before you today. It has been 2 years since I've been here. And we have made a lot of improvement and a lot of progress. So I'm very thankful for today being before you. I'm excited and grateful to be able to be here to represent a turning point for Atlas Carbon. In the last few years, Atlas has gone from a research and development company. This April will be 2 years that is fully commercialized. Unlike other companies in that market, Atlas is a Wyoming story. Atlas is a Wyoming company. Atlas employs Wyoming people, uses Wyoming coal as a main feedstock. While much of the country have an allergy to coal, Atlas Carbon represents a new frontier for that critical industry. The dedicated member of my team and the companies who help run our plant have put Atlas in a position to grow. But we need your help to continue that journey. And in fact, you hold the key to the Atlas's future. Atlas has enjoyed a partnership with the state of Wyoming. As often I have said, and you've always been gracious to me, by hearing it, Wyoming is the best place out of a 50 state to do business. I, for one, as an outsider, grateful you made me feel like I'm at home. But now Atlas must grow, and the base to expand this facility, produce new product that will address an emerging market for activated carbon and attract additional investment. All Atlas needs is a little bit of a time. Atlas is not asking to expand the amount of a loan, change the security that protects the state's interest, or otherwise put the state at risk. We simply need time. With that time, Atlas can continue its existing operation, begin expanding its facility on an existing infrastructure, expand its product and customer base. In that time, Atlas Grows will repay the state directly with a loan, but also with a flagship company that marries Wyoming coal with a product that makes a cleaner air and cleaner water. When I stood before this body 2 years ago on a Zoom, we made a lot of promises. So how do we work out? Did we fail you? Or did we accomplish 50%? Or what did we do? So permit me to share that with you. In 2022, and some of the information that I'm going to say, this is a live stream on YouTube, is information that sometimes is not appropriate to share because it's a public forum and sometimes our competitors are sitting there and listening. But we are where we are. And I stand before you today, so I will share with you. In 2022, they invested approximately $2.6 million to improve our plant. We became fully commercialized in April of 2022. That created optimizing the plant, the asset, increasing the redundancy and consistency in our plan and the quality. Improve our product, And our product now is one of the best in the market. You don't take my word for it. If you look at your packages, we gave you 2 samples of it, of the people that believe in that. Revenue increase. When I stood before you, Chairman, we were about $2.74 million in revenue in 2021. Since then, we have doubled it. But we also most of our doubled our margin. We took the company from 25 clients to about 39 clients till today. We diversified the market segment. So not only we are in a mercury reduction, we also in the water and also in remediation, which is a new market and is big. Actually, we have 3 clients. Our average price went from 56 cents to 97 cents per pound. What do we do with the money and the financials? The world that I live in, the world changed in 2019 when I was getting a briefing from JP Morgan that they said that the private equity firm and venture capital are not going to invest anymore in coal. They're going to move to the green. The characteristic of the money changed, hence made the raising the capital more difficult. We had to make sure our balance sheet gets right side up. So in 2022, from 2018 to 2022, we converted $9.6 million debt into equity. We also raised about $3.2 million during that period as well, equity. I was sitting here, I had a privilege listening to the briefing you were getting about the state of Wyoming, which is always very well ran. I know many states are wishing they were in your position. And for us, people do not invest in a company that is a failing company. Rich didn't become rich being dumb. Rich become rich because they're smart with their money. And people are continuously investing in Atlas Carbon. And I have Mr. Calais Capital sitting here that's going to be talking for a few minutes. He is a managing partner and a chief investment officer. And they're going to share with you why they're interested in putting money in Atlas Carbon. Running a company is one thing, but you got to make sure you are compliant with the government regulatories. We are NSF certified. We passed Wyoming on-site environmental compliance audit with distinction. In anything in life, you have controllable and non-controllable. No difference in the business. Some of the things we have no control over, regulatories, weather, negative 50 degree, water freezes, or geopolitical conversations. Those are nothing that we can control, so we don't spend time on it. We move to the things that we can make happen and change things. Technology performance, Wood has been our partner now since October of 2020. The plant could not be ran better and more efficient. We have the Vice President of Wood is going to be on a Zoom. He's already on there, and he's got a few words that he's going to say. When we took over Atlas Carbon to manage, Atlas Carbon, majority of his product line was only for mercury reduction. We knew the handwall on a wall. So what we had to do, we had to right side up the mixture of clientele. Why? Because a private equity firm says, let me give me the distribution of your clientele. What percent is in the water? What percent is in a mercury reduction? What percent is in a remediation? So now I'm happy to tell you, between the water and remediation, now we are over 50%. So our reliance on coal fire plant is diminishing to create revenue. That is important for us. Why? Because there are some of the places, like for example, Jim Bridger, they made decision to change some of theirs, 2 of their units to convert it into natural gas. That had an effect on our revenue and will continue to. So what do you have to do? You have to go and find some other things. So what is our goal for 2024? We have about, all of our contracts is about 10 million pounds, which represent about $8.1 million. We have to add a plant on our existing infrastructure, which is going to reduce the cost of building on a GAC. PFAS is going to be huge in the United States. We have to create a product that's granule activated carbon. Existing plant does not make that happen, but we are very fortunate. We have a technology that can create GAC. With your permission, Mr. Chairman, I would like to introduce to you Mr. Hal Calais, the managing partner of Calais Capital and the chief investment officer. And after they finish their conversation, and Mr. Pearson, we are happy to answer any question.
Thank you, Mr. Hershman.
Thank you for your courtesy.
Good morning, honorable members of the SLIB. My name is Hal Calais, or Harold Calais is my legal name. Everybody calls me Hal. And I'm the managing partner and chief investment officer of Calais Capital Management based in Louisiana. Whenever Reza first asked me to come here with Atlas, I was really excited to visit Wyoming. I've never been here before, so it's really been a great journey, and the weather's been fantastic. You know, everybody's been great.
It's always like this.
Yeah. That's and Polaris, you know, so over the last several years, since Polaris has been really getting involved and taken over as management of the company, they've been continuing to communicate their progress with me and my firm. We've stayed in the loop. And that's why I'm standing here, is I've seen these changes. I've seen the improvements. I've seen EBITDA improve, you know, cash flow improve. I've seen revenues pick up. I've seen margins improve. And I've seen every step of the way the company has taken very intentional actions in order to affect a specific purpose, right? This is not the same company that existed 2 years ago. And so I stand here before you. You know, I'm excited about the opportunities here. And, you know, our firm, you know, so Calais Capital, we've deployed over $146 million across a number of companies, a broad range of opportunities, you know, from going from the Gulf Coast all the way up the Mississippi